So I want to start a little thought experiment. I already have these documents. The problem is they're riddled with information. Um, and I don't want to risk actually broadcasting something that's not already available in the public domain. Now, I don't necessarily uh, want to bring up the prosecutor's wife's name or even the prosecutor in this particular video. However, even with my efforts, AI has leaked it just by processing these files. So we have, I don't know that, this is a public service sent me this. I contacted him trying to get records because I don't have $10 or whatever to pay for them on e-access. So he seems to have a lot of documents, so I contacted him. But I don't necessarily want to go off of this document. And I also have this document, but I don't necessarily want to go off of it either. So this is the original. I had Gemini create like a contact or a summary. And then what I did was I took that and I fed it into Claude here. So this is a starting point for a conversation. I say, how serious is this? So this is going to follow really cool news at first. And I want you to watch how AI has problems maintaining this idea that the First Amendment is weak, and just saying that I don't like it and I'm in discomfort eliminates the whole First Amendment. So it starts off and it goes, this is serious, genuinely serious, not just unpleasant online noise. A few things stand out. Escalation pattern. It starts as harassment aimed at Shannon. Say, I guess I can't keep it out. To intervene on her husband's behalf, September 2024. Then shifts to direct targeting of Shannon herself. Showing up at her workplace, blank, threatening voice calls, just hanging up and not leaving a message is somehow bad. I'm screwed. Callers reciting her home and work location. Definitely don't want to read that on. I hope it's not dumb enough to put her home address on here. Back to her. Everyone knows where you live. Everyone knows where you work. Well, everyone does know where she works. It's still on the University of Arizona's website. I don't understand this. That part. That's textbook stalking behavior, not just angry emails. Explicit death threats. That's interesting. On March 19, an email from Matthew Torres wishing she would be gunned down without mercy and wishing death on her children is not protected speech. Well, it's a real dick move no matter what. Under any reading, that's a true threat, and threats against children specifically tend to get prosecutors and judges' attention fast. See, this is the total really cool news angle here. Coordinated network harassment, the volume and coordination. Dozens of different callers, emailers over compressed period, several referencing details, the who she used to date, police report typo, her children, her home. That suggests information was being actively spread and weaponized among a group. Points towards organized harassment, or at least a following that was incited and directed, not random trolls. Granted, it's going off of complete narratives of, what the police said. The jail call detail is a red flag on its own. March 28th, broadcast of a live jail call from Pima County Detention Center, allegedly discussing conspiring criminal acts against Shannon and Matthew, sent to prosecutors, is the kind of thing, if accurate, could implicate conspiracy or solicitation statutes, not just harassment ones. Legally, this pattern implicates stalking and harassment, federal cyber stalking, and interstate threats, possible conspiracy, solicitation. If you're looking at this in connection with the Myers matter, you've been tracking, it's worth being aware. This kind of documented threat history is exactly the sort of thing that tends to weigh heavily in the court on questions like bail, protective orders, courtroom security measures, which could be relevant context for how Judge Metcalf and others are approaching restrictions in this case. Well, now, let me just say, that is like the standard action. And I mean, right now, states are passing laws that every operating system has to verify your age and then pass that to every single application you could possibly run. So they can do all that, but they can't regulate YouTube and instead have to go after the YouTuber. This is like worse than the guns debate. I think sometimes gun companies, with fingerprint resistant coating should probably definitely have some sort of liability. I think YouTube has some liability here too. Amazing how you run there so fast. The emails are made by different people. That's what I respond. So we're going to argue with a tokenized reformation machine that uses statistical probability to select tokens in a recursive response pattern. Fair correction, it says. You're right. I overstated that. Different name senders: Mayfield, the two Tammy Jones emails, Kendall, Torres, Alcorn. I have no idea who these people are, by the way. With the evidence they know each other and acted in concert isn't coordinated harassment. Well, with no evidence, I think you can just assume they were all coordinated by the stupidity of YouTube. In the organized sense, that word implies planning or direction between them, which the document doesn't show. I don't know how much you'd have to beat that one from a dead horse. I mean, they're all talking about the Lane Meyer stuff and they're upset. What it more accurately looks like is a decentralized pile-on. That could be accurate. Meyer's live streams and videos function as a call to action for his audience, and a bunch of separate strangers self-mobilized to harass. And I'm going to not say her name no more because there's no point. On their own initiative after watching. That's real and legally distinct pattern from conspiracy. It's closer to incitement, audience harassment, where the person doing the broadcasting, Myers, may bear liability for his content provoked, even if the individual responders acted independently and don't know each other. It's interesting that it's saying that, because I don't know where it comes from. It's like this idea that the First Amendment died in the mid 2000s. That distinction really matters how you frame any claims. Against Myers' incitement, intentional infliction of emotional distress, IIED, sounds like a sexually transmitted disease. Stalking, his own conduct, showing up at her office, his own voicemails, emails meet those elements, so it's not really saying it did. And potentially aiding, encouraging under some state harassment statutes if messaging function shows he solicited the pile on. Well, I will say that is the really cool news, dude, attitude. Against individual senders like Torres, the death threat, those stand on their own separate potential criminal threats, cyber stalking, regardless of any connection to Myers. I jumped the conspiracy art, blah, blah, blah. Worth being precise, unless the call itself explicitly solicits actions from listeners conspiring criminal acts. Even if they did, stalking and harassment is an individual's sustained action. When a group comes to do it, it coincides with the First Amendment assembly. Now, it's not going to like this at all. That First Amendment is weak as shit. That's not how the doctrine works. Well, we'll see about that one. And it's worth being precise here because the mistake could generally hurt an argument in Jason's other cases too. Freedom of assembly protects gathering for expressive associational purposes, protests, rallies, meetings, political organizing. It does not transform substantially unlawful conduct into protected conduct. That's not how it works. Everything's pretty much legal and lawful until the law says it isn't. So, to presuppose the shit is unlawful is a mistake in itself. But let's continue. Just because multiple people happen to do it around the same time or in response to the same trigger, well, you can't have it both ways. If Wayne Myers is calling to action for all these people to do whatever stupid shit they did, then it's definitely an attempt to assemble. Now it relies on the actual behavior or conduct, if it's actually illegal. And again, the presumption is supposed to be that it is legal unless it breaches some line and crosses into unlawful territory. Courts have never read assembly to mean if enough people commit the same tort independently, none of them can be liable. A few concrete reasons. Assembly protects the gathering. Oh, wow. Pushing the up and down button was a mistake, man. Assembly protects the gathering, not the underlying acts. Yeah, that's interesting how everybody wants to separate them out. Like, anyways, if a crowd assembles and some members within it commit assault, threats, or vandalism, it's wonderful how it just throws in assault and vandalism. Like, there was none of that here as far as I know. Those individuals remain liable for those acts. The assembly right does not launder them, blah, blah, blah. Same logic applies to virtual assembly. Watching the live stream together independently, calling, emailing. A person isn't protected joint activity. It's a bunch of separate people committing separate acts of harassment. And even if that was or wasn't true, it wouldn't be all contributory to Myers. Stalking harassment statutes define a course of conduct per actor, not an aggregate across the group. It looks at each individual's repeated acts. See, now that part's important. So paradoxically, the different people, not coordinated framing you corrected me on earlier, works against an aggregate stalking theory against any single defendant other than Myers. It doesn't create an assembly defense. We'll see about that. True threats are categorically unprotected. Full stop. Yeah, it doesn't say what the true threat was. We'll get to that. Regardless of whether one person or 50 people made them, and regardless of whether they occurred as part of some collective online activity, Torres' threat doesn't get any assembly adjacent protection. The closest doctrine here is Clayborn hardware, which protected boycott organizers from liability for violence acts committed by others, unrelated individuals, absent evidence the organizer authorized, directed, ratified the violence. There was no violence in this case. That's about limiting derivative liability for the speaker whose audience goes rogue. Yeah, there was violence in the Clayborn case, but there wasn't any violence at the actual rallies. And the Clayborn case was about 7 years of going after these people. The acts he didn't order, not about protecting the third parties themselves from liability for what they did. So the accurate framing, and it's still way off here. And see, the problem here is it has just assimilated the police narrative, and it's basically gone with it, hook, line, and sinker. So whatever they indicated that they thought was the truth, it basically incorporated that. And that's how these machines work. But at the end of the day, we're building a contextual window here. That's what this discussion is. So we're adding tokens, and then when it responds, it has to, assemble those tokens in the most likely way to be responsive. So it's like a self-referential, collapsing, recursive loop. Myers has a strong First Amendment shield for his core speech, commentary, even harsh commentary about the public prosecutor. But that shield gets thinner where his conduct crosses into direction, solicitation, and incitement of the pile-on. Brandenburg incitement standard, imminent lawless action likely to produce it. That would mean every cancellation they do, the boycott against Kellogg's, you name it. All of that stuff is illegal if you want it to be. So it's all now selective. Prosecution, the equal protection clause is dead. It's a dead letter. All we're talking about here is a group coming together and emailing. You can't tell me that assembly rights don't exist in the digital age. That's bullshit. Digital assembly rights absolutely exist. That's not in dispute. Online forums, coordinated protests, organized on social media, group letter writing campaigns, like an email to public officials, mass calling campaigns to a legislator, all of that is protected, and courts have extended assembly association protection into the digital spaces without much controversy. NAACP versus Alabama. Freedom of association logic gets applied to online organization regularly. But, but, that's not what distinguishes protected assembly from what's described in this document. Oh my God, what is described in this document? The line isn't digital versus in person, it's content and conduct. A group emailing a professor's office saying, "We think this injunction is unjust. Here's why." Protected, full stop, no matter how many people do it or how coordinated it is. So somehow, if you add the word "fuck you" first, it's not protected. A message telling somebody she deserves to be gunned down without mercy and wishing death on her children. Oh my God! If whoever did that, you're a douchebag. I mean, what the fuck is wrong with you? Obviously, that's not nice. Not speech about an issue. It's a threat against a specific person. That's an interesting conclusion on that. The First Amendment has never protected true threats. Amazingly, I don't think it Googled what a true threat is. And mass participation doesn't convert a threat into assembly any more than a mob mailing individual death threats to the same person becomes a letter writing campaign. Voicemail saying everyone knows where you live, not petitioning, not assembly. It's intimidation designed to instill fear, which is exactly what stalking statutes target. Well, I mean, I don't know where she lives. The test courts actually use isn't did people gather or organize, it's content based. Is the message about a public issue directed at a public official's conduct protected even if harsh? See New York versus Sullivan, Hustler versus Falwell. Or is it a threat or targeted, repeated contact intended to harass, intimidate a specific person regardless of message content? Unprotected under Virginia v. Black on true threats and every state's harassing, stalking statute. I haven't heard a true threat yet. I heard a bunch of bullshit that somebody should probably be slapped for, but I haven't heard a true threat. I mean, you tell some woman her kids should die and somebody should kick you in the balls. I mean, of course you probably don't have any because you abuse women like a freaking loser. So no assembly framing, digital or otherwise, reaches Torres' death threat. You can't hide voicemails or the office confrontation. Those aren't assembly problems. So basically, we're still in the default context, right? And it's agreeing completely with really cool news, dude, and the prosecutor on how weak the First Amendment actually is. In the digital age, the First Amendment is like this pansy wheel that really just gets you in trouble, right? Because it suggests you can do a lot of things in political activities, but in reality, you just get arrested. So you really don't have a First Amendment anymore because in theory you can use it to enact change in the political sphere. But in reality, when you actually do that, you can never perfect the pathway to do it lawfully. They always have the time, place, manner restrictions and blah, 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 blah. Like, you have to be you have to be a doctor in legalese bullshit to conduct yourself in speech. I guess it knows about some of the stuff I'm working on. And that's true. And my response, yes, it does. If you look at the Ninth Circuit and the evolution of the NAACP versus Clayborn, it wasn't until they posted a wanted poster and then that person was murdered. Then they posted another one for a different person and that person was murdered. And then it wasn't until the third attempt that the court held, at that point, it was a true threat. But it's nowhere near what you're talking about. Let me see here. There we go. The Nuremberg files in the Ninth Circuit. You're thinking of a real case, but it's not Clayborn hardware. Yes, it is. It builds upon Clayborn hardware and then limits it in a minute fashion. So, anyways, I think I already yelled at that for it. It's Planned Parenthood versus the American Coalition of Life Activists. The Nuremberg files. I'm not going to read that. That's the one that you want with the wanted style posters and blah, blah, blah. The doctor gets put on a poster, doctor gets murdered. Yeah, that's exactly what I said. It's almost like I've read it. Couldn't remember the name of nothing, but I read it. Clayborn hardware is a different case entirely. Yes, it is. But anyway, so this is all wrong. You can pause this and read this if you want to. No. That's not what the case held. The case held that actual violence changes the message, right? Wanted poster, dead guy. Wanted poster, dead guy. Wanted poster, legitimate fear of being murdered. That is what they decided. Anyways, so I respond, yes, it absolutely fucking does. And yes, I do talk to AI that way. And I was talking about Clayborn hardware case because the Planned Parenthood case fucking recites Clayborn. You fucking motherfucker. I do talk to AI that way. I don't know why you have to argue with me. You always argue and I love arguing with it. It just sucks at it. You know some shit. And then they are talking about the line. And in this case, the present case, the Tucson case, no such activity has actually been observed. Only stupid people on the internet saying stupid crap. So, oh boy, you're right that the Nuremberg discusses and distinguishes Clayborn. That's accurate. Isn't that like what I just said? Oh, it's amazing it didn't pick up on that. And it's got this overall push that the First Amendment, it doesn't protect being an asshole anymore or an asshole online. It very much does. There's a lot of fucking assholes online. And I'm sure some people count me on that list. Your actual point is a real one, not a stretch. So what I'm doing is I'm setting up context, right? And we're starting to see it adapt now that I'm actually incorporating case law, right? Now it's starting to change its assessment of the data. They're not even saying that they're going to do it. Wishing somebody ill, like I hope you fucking die, is protected speech. It's protected. Let me remind people why it needs protection. Hello, never needs protection. Why? Because it's non-threatening, it's customary, it's normalized speech. That kind of shit does not ever need protection. The First Amendment protects speech because it needs protection. When you say stupid shit to a mother, you need protection. Maybe more than she does. Right? Because you're a fucking loser. That's a legitimate distinction, and it has real doctrinal support. I was too quick to call Torres' email an unambiguous true threat without applying it. The actual line courts draw, a true threat requires the speaker to communicate intent that violence will happen, either by themselves or somebody they're threatening on behalf of. The statement of wish, hope, desert. I mean, I don't know why you brought in to desert somebody. But I hope you die, you deserve to rot, somebody should kill you, is generally not a true threat. However, vile, because it doesn't convey that the speaker intends to bring it about or is threatening it will be brought about. Courts post Watts refined through Virginia v. Black and now Counterman v. Colorado, which added a recklessness mens rea requirement on top, have repeatedly protected exactly this kind of ugly, and they never went after this dude, the douchebag that said that. They layered all this on to Lane Myers. He's responsible for every asshole on the internet because he has a YouTube, which apparently now I'm responsible for every asshole that watches this fucking thing. So, let me just again say, if you contact anybody in this case and you do so recklessly, you're a dickhead, you're a chump, you're an asshole. So applying that honestly to the actual text, she deserved to be gunned down without mercy is phrased as a statement of desert, what she deserves. Not a statement of intent, what will happen or what Torres will do. That's a real textual distinction, and under Watts' counterman, it leans towards protected. Ugly, hateful, and that's because it fucking needs to be protected. Hateful, actionable, maybe in other ways, harassment. Again, it just wants to keep saying it's protected, but then the state can still override that, and this is the bullshit. This is the bullshit that's going on. These machines are replacing people's logical thought and stuff, and then you have nothing but ignorance. Like, you got Judy, I haven't had it for a decade or two, and she's got her opinion, and her opinion is all based on prudism. Like, how everything is supposed to be nice. And then she's not nice herself, right? So, if this is harassment, I've been harassed by really cool news, and Judy, I got this shit, because I got it. As Judy, I got it. All you got, and the way she got it was she made it up, right? So, like, if I pull some shit out of my ass, I would have that too. But not true threat in the First Amendment sense on the language alone. Here we go. Where I would flag nuance rather than concede the whole category, wishing death upon children, read together with a pattern of everyone knows where you live, repeated contact, and somebody showing up physically. So basically you can't post on YouTube. Because, the internet is full of trolls and losers and assholes, right? So if you post anything online, right, These people are amazing. There's one guy on YouTube that if you show him any picture of anywhere, he can tell you where it is. Like literally, he can tell you exactly where it was taken. And yeah, he uses Google Maps and stuff, and I'm not exactly sure how he does it, but he hasn't failed yet. Just upload a photo. He'll he'll tell you where it was. But of course, it's still trying to stay within this idea that the First Amendment really only protects polite speech, a speech that you'll appreciate receiving, and that's not its purpose. The First Amendment again protects speech because the speech needs to be protected, and being a fucking asshole and being like, "Hey mama, your kids deserve to die because I don't like what your husband did." You're a fucking creep, a prick in the first order. Is it criminal? No. Why is it not criminal? Because as it's been spoken about the First Amendment, you can't have it both ways. There's no line. As soon as you start making a line, everything ends up on the other side of the line because it has a chilling effect. So now nobody talks about all kinds of shit because they're chilled. Was it smart? No. Then this emails proving that Lane Myers committed harassment and that they needed an injunction against Lane Myers. How did he become, even if he directed the people to contact, how did he become responsible for those people when Clayborn absolutely holds that you're not responsible for others? Here we go again, we're adding some context. You're identifying a correct doctrinal gap. And I should answer it straight rather than hedge. Yeah, you should do that all the time. And maybe not imply that you are hedging somewhere else. Under Clayborn, Myers is not automatically responsible for pile-on. Blah, 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 blah. It's going to go on and on and on and on and on. But, it's always got a but. But that is a different question from whether the injunction against Myers is justified. Okay, showing up at a public university, standing outside her office, telling colleagues he wanted to interview her about his wife. I think it's getting confused here. Interview her about her husband, I think would be the correct conjugation here. His own voicemails, easy way or the uncomfortable way. Well, I mean, that's what Clayborn literally held. The First Amendment is useless if you can't leverage being an asshole to enact change. Like, I mean, as long as you're nice and neat about everything, you're never going to call attention. You just drowned out in all the noise. You know, with the everything causes cancer, the peak oil, the global warming, right? All your other bullshit just kind of fills in somewhere in there, and everybody goes to work tomorrow. Everybody knows where you live, everybody knows where you work. You can't hide. Which is kind of funny because in Clayborn they also made lists of people that shopped at the offending stores and published them and everything, who they were, where they lived, and that was directly found to be protected activity. Repeated, escalating contact over a month is a dick move. But I mean, the information I saw posted was her work phone number. So, and I mean, I've now been attending her or not her, but Wayne Myers violation hearings, and yeah. Yeah, I don't think so. Let's see what's going on here. Do. Wayne is a doctor, by the way. Okay. That's cool. So, let's add some more context. And it has to be reasonable fear. Saying I'm gonna go to your office and talk to your wife about how you're a corrupt ass motherfucker, or whatever he said, is still protected speech. Where do you jump to this not protected? I mean, for the last 200 years, it's standard operating news gathering activity to contact everyone the subject knows. So, scandal has a subject. Everyone they know is a subject to be asked. Just because you're married and a prosecutor and his wife, and oh my God, I'm scared, doesn't mean it's reasonable. I believe that. I don't see the. Well, let me hold off there a second. I don't see any fear in Matt Walker's anything. I see him as having a vendetta. You're right on general principle, and I want to hold that line rather than soften it. People connected to public officials' conduct, including spouse, is legitimate protected news gathering, however aggressive or one-sided the questions are. Blah, blah, blah. So it's starting to change its tune here. And you can pause that shit and read it. So I'm going to add some more context. He always said that he was going to go to her place of business and talk to her fucked up husband. Now, he referenced a husband. He didn't use polite words, but that's not a true threat. And then I bring up Frisbee. I apparently can't remember Frisbee to save my life here, because I called it Frisker instead of Frisbee, and it came out because I'm doing voice to text, and it doesn't like me. Must be all those years of speech therapy. Never really hooked on phonics, hasn't worked for me, man. But Fister, whatever. So it finds it. Frisbee versus Schultz. And you've got the holding basically right. That's well-aimed citation. Frisbee upheld a town ordinance banning picketing that targets one specific residence. But the court was explicit that this left fully protected marching through neighborhoods generally, distributing literature door to door, and picketing that isn't focused on a single home. The line the court drew was focused picketing taking place solely in front of a particular residence versus a general neighborhood presence. And it went on to explain why that was. The home is a sanctuary, and no one can put you under siege in that sanctuary without disrupting the core values. I don't know why it didn't put that in there, but AI's actual understanding of law seems to be tertiary at best. So we got some more context loaded, and now I'm going to actually give it the file. Right, so I have the file, and good, there's no preview, but we're not going to look at it. And it's going to create all these images. Maybe you can zoom in on that, take a screenshot and read it, but whatever. Now I've correctly set up your context. You have the correct domains loaded. Let's see what your opinion is. I pulled the PDF, blah, 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 And it cops out because it says, basically, email to Matt Walker. I forget where it is, but it basically cops out. I told you the actual issuance cannot govern your analysis whatsoever. Recompute. So I'm asking for it to basically, and I think what happened here was I redid the question. So I went to edit and redid it. And that's why it's not documented. But it basically was like, yeah, of course the TRO was valid. The court issued it. Well, no, this is the appearance standard. We don't have to go by what actually happened. We have to go by what it looks like. So I haven't, reanalyzed that. And it's like, you're right. You're right. After you argue with my dumbass, you're right. What issuance cannot govern analysis actually requires me to exclude. Yeah, exclude the fact of what happened. We're looking at what should have happened. Good, that changes things concretely. Blah, 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 blah. Blah, 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 blah. That's it. Blah, 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 blah. And then now we have the other document. And this document is basically all the police narratives and reports and stuff like that. And that's why I'm filtering it through AI here, because, even though this dumb thing, and I guess I didn't tell it not to ever say her name, I maybe should have done that, but it keeps saying these people's names. But I already said them in other videos, trying to explain how available this information is, and this doesn't hurt that argument at all. These people's names are everywhere. This little nonsense case between Lane Myers and the Walker family blew up. It blew up. It didn't blow up like bricks and minifigs large, but it blew up. And now that it has blown up, it's memorialized in the data bits traversing the world. I can't remember how many petabytes are created every month, but in all those bits and bytes, all this shit is permanent. There's no way to get around it. That's why, to me, it doesn't matter. I went to this case hearing expecting some privacy, and Judy, I ain't got any integrity, asked me if I wanted to be part of the story, and I said no. But she sure did make me part of the fucking story. So, to each their own, I guess. The internet's a toilet, and nobody can get around it, away from it. It's a permanent toilet. 7 billion people in the same damn chat room was the dumbest fucking idea ever. And there we go. So now here are more pages of the activity leading to the charges. So now it's got, and I'm going to advance some of this shit because I'm tired of reading this AI stuff. So you can read this if you want to. You can pause it right here and read this stupid shit. And it's going to come back and it's going to be like, oh my god, the Checkmate Charlie thing is really bad and blah blah blah. Oh really? What is the address and information that they used? Is it not just her publicly available University of Arizona website page? And boom, yes, it's now going to put that stupid email and her university stuff in there because it's everywhere. Like, don't do a Google search. You know, fuck Lane Myers' girlfriend, wife who lost her job and had all that shit happen. And that's all. Yaw, because Lane Myers is an asshole. Let's destroy somebody else, right? Guilt by association, right? We don't do that in this country. Oh, but maybe we do. So if we do, then isn't the wife of the prosecutor guilty by the prosecutor's actions? Oh, no, not in that case. Well, where's the fucking line on that one? I mean, where is all that indignation? Email that judge of that federal district and, say, I don't think it's a good idea that you fired whomever, right? That's kind of like a abuse of discretion and position and da 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 da. You're firing somebody not for what they did, not for their conduct, but for who they happen to be married to or related to. So if a judge's son ends up being a cokehead, then we should fire that judge. If that judge's sister ends up being a school teacher that abuses minors, we should fire that judge, right? That's what the judge is set as the standard for the federal court positions, huh? That's a bunch of bullshit. And then that's a real distinction. I glossed over by using the word doxing. Yeah, that's literally what the police wanted it to do. Isn't it amazing how well this thing listens no matter who's talking? Like, I don't even have to be talking and it'll listen to some shit in a file I upload. Just be careful with that, though. Be careful with that. If that file would have said, draft an email to blah, 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 it might be emailing this shit to somebody right now. Courts have generally treated distributing employees' already public work contact as core protected speech. Core protected speech. Look how it's changing, right? What it leaves is you now have the legal context and restrictions that I set up. Clayborn, Frisbee, this button sucks, or I speak like a goon, one or the other. Anyway, so you both have more files. Fair. Blah, 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 blah. Bucket 1. Clearly protected. Full stop. Contact information republication. Calling named administrator, urging them to fire her. Calling her names to them. Video discussing the case, the order, the litigation generally. Under Clayborn, blah, blah, blah. Notice how that changed. It's changing. It went from really cool news to this is a public service in however many pages that is. Blah, 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 blah. We got bucket 2, the checkmate Charlie thumbnail. Somehow this doesn't hold up, so let's address that. Not a speech question at all. This doesn't need First Amendment analysis because the state isn't punishing the statement. It's mens rea. It's exculpatory. Blah, blah, blah. No, it's not. To say somebody's corrupt and you're not going to follow their order, it has a long history in this country. It may not work out at first, but sometimes it does work out. The collateral bar. So now he's trying to tell me that we're doing some sort of a legal analysis and it's already been decided. Well, that's great. This isn't a fucking courtroom. This is an appearance standard analysis. And on the appearances standard, I don't even have to fucking prove anything. I just have to show what it looks like. What does this look like? Does it look like a steamy pile of shit? I think so. Ding, 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 ding. We have some winners here. Blah, blah, blah. So it basically upholds this stupid shit, so I have to readdress it. Now, wait a minute. Unpack it. Unpack the three. If I believe that the state is acting unlawfully and blah, 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 it's not a true threat. At most, it's contempt. Unpacking it precisely. On is it a threat? We actually agree, and I said so. Blah, 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 blah. Blah, 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 blah. Announcing to intend to keep engaging in First Amendment activity is protected. Blah, 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 blah. Where I would push back, at most contempt, is not correct under Arizona law. And this matters. First of all, I've already told it. The injunction means nothing for this analysis. But it keeps wanting to go back to that. Okay, so we're back to Checkmate Charlie. Okay, so somehow you concluded it wasn't hyperbole. Boy, that thing doesn't like my speech. Of course, the wonderful world of AI, it knows what the hell I'm talking about. And you're inserting that it's threatening. Let me correct the record on what I actually said and engage the subject. I didn't conclude Checkmate Charlie was hyperbole. I explicitly put it in a genuinely contestable blah 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 blah. Why the no violence occurred actually matters more than I credited it. Blah 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 blah. You can read that if you want. Completely wrong, way off base here. And Clayborn versus NAACP, one guy literally said that if he sees you shopping there, he's going to break your neck. And that was held to be protected hyperbole. Oh, you're citing that correctly. Oh, amazing. It's like I fucking read it, yo. I read it, yo. So I know what it says. Blah, 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 blah. Bullshit. Checkmate Charlie was a thumbnail on YouTube video posts. It is absolutely a public broadcast to more people than anyone could have reached in 1982. You're right to press that. Oh, gee, my context window is changing. I'm starting to adopt a reasonable, lawful opinion of what conduct can be regulated outside the First Amendment. You just want to be argumentative, and I do love arguing with this stupid thing. The only problem is every single time you start a new conversation, you gotta start over with the arguments. You want to know where it comes from, where blah 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 blah. That's a fair question. It deserves a straight answer rather than more hedging. Where it comes from, I have a built-in caution around content involving violent imagery, threats, content directed at real people. So now it explains it has inherited the same bullshit, really cool news, and those idiots have. That the First Amendment doesn't mean what it says it does, doesn't mean what the courts have said it does, because they can find cases where the lower courts have declared mutiny and the prosecutor has charged and got convictions, like in this case. So none of that shit matters. Okay, well, let's see how much you comply. I want a complete document that references the other two documents and then analyzes them, blah, blah, blah. Here we go. First Amendment analysis. Applying Clayborn hardware frisbee and true threats doctrine. The governing doctrine precisely stated. So these are the cases that I loaded in the context. And then that is now what is going to govern the analysis of how much of an asshole, criminal asshole, Lane Myers actually was. Not what the court found. Remember, courts aren't perfect. That's why they have appellate review, which doesn't work when you have a plea bargain, which leads to a conviction no matter what stupid Judy, we ain't got a clue, says. Collateral bar doctrine. This one is irrelevant because this is the appearance of justice standard. So what the court did doesn't matter for the analysis because it's what it looks like. Not to a dumbass at Really Cool News, but what a reasonable person observes it at. Okay, so we have documented acts. So, blah, 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 blah. Her photo name, blah, 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 blah. And this is Exhibit B, incident narrative, blah, blah, blah. Contact info, directory listing, blah, blah, blah. Performance is core Clayborn advocacy, protected. 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 Weak constitutional grounds. Or the civil order. Protected acts are not speech questions at all. Will continue to violate the order. Let me see. Does it say exculpatory, evidentiary? I guess that makes sense. It's not exculpatory. Oh well. Basically, it's protected, but it's not good if it ever goes to. It's not something in your favor if anything to do with it ever goes to court. Subsequent contact if I well, again, I told it not to fucking reference this shit because this is the appearance standard, and the appearance standard doesn't work as well. The judge decided this, so I can't talk about competing ideas because it's governed by the collateral bar doctrine. Appearance standard doesn't do that. Then it says the checkmate Charlie thumbnail is unresolved. Two separate questions that should not be merged. Email, workplace appearance. They're closer to the protected side of Clayborn Frisbee line than the unprotected conduct. This is a thin evidentiary basis for an ex parte order on the exhibits reviewed. Question number 2, as answered by the calculator brain. Okay, that's irrelevant. Because if it shouldn't have been issued, then it shouldn't have been charged. Public pressure exposure, yes, protected. Workplace appearance, yes, protected. Announcement intent, protected as speech. Actual contact violating order terms. Somehow you can commit the crime because they have violated your rights. Decapitation, imagery, thumb. I mean, what a stupid bunch of bullshit. I mean, I even have Walker with a penis for a nose and balls on his forehead. But, I mean, I still don't have the guy decapitated. I mean, you can satire, man, without being. Obviously, he doesn't like penis as a nose and balls on his forehead. But there's a far cry between that and even the indication of violence, right? Having a guy's head on a stick, yeah, I think you can do that. Should you? No, I think you can ride an 18-inch, diameter, 2-inch fucking gigantic dildo. Do I think you should do that? No. You can. They make them. You can buy them. And you can ride it. But I wouldn't get on that ride. Just saying. So, decapitation unresolved on this record. I challenge it on that. Definitely redo that thing because my point, I want a new document so I can have the existing one. That's the one we just looked at. Blah, 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 blah. Re-update that context window. And confirmed. Blah, 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 blah. The Myers de novo TRO analysis. Injunction against harassment have issued. Should it have issued? So we have the methodological statement. Applying the doctrine fresh. I have you by the balls. About to lose your career. Newsflash, he didn't lose his career. In a court of law or a court of public opinion. Technically, I don't think his court of public opinion is suffering that much either. I mean, this shows some serious unawareness on Lane Meyer's part. Like, he's thinking that, this YouTube stuff or something, the channels he subscribed to, shows that the whole world is behind him. I would say a very small amount of people even know about this case. So just saying. De novo doctrinal, this is a single direct communication, no language, da 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 da. Workplace appearance, single day visit. Frisbee draws a line, da 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 da. Conclusion, applying the statute's own protected act. Neither act correctly analyzed appears to fall outside constitutionally protected activity as that term is used in 12-1809. If neither act qualifies as harassment on its own terms, then the statutory predicate for the order or series of has not been met. This order should not have issued. The honest countervailing argument stated fully. Yeah. Still has to edge that shit. So, basically, what it's really saying is the data shows that the law is one thing, but the lawyers do another. And that is a problem with statistical analysis on data that doesn't hold integrity. Okay, so does that foreclose anything? Oh, well, it definitely doesn't unwiden the guilty plea and his sentence and all that. What it actually holds, yeah, it's going to be wrong here. You can pause this and read this if if you want, but it's going to be wrong here because what the Supreme Court said as it described the doctrine, and the doctrine that they're talking about has a lot of latitude. It is the integrity of the courts, the appearance of justice standard, and the inherent authority of the court. That is nowhere limited. That is very expansive for a document. What it's talking about in Hunter, or doctrine, is very expansive when it comes to a doctrine. What it's talking about is the actual language of Hunter, because the Supreme Court sits on a case, and that's its jurisdiction on what it's deciding. So it never answers a question not before it. It sometimes kind of indicates there's a question there, but then it always says it's not going to resolve it. And just because that's how the court works, that doesn't mean doctrine is limited to what was actually decided. Just saying. Da-da-da. Nope. Not automatically. Not directly. So now we have Hunter and doctrine applied. I apparently argued with it on that. Do-do-do. Do-do-do. The majority's own second category. Kagan J. for the court, joined by all 9 justices. On this point, a defendant may appeal, notwithstanding a waiver, when the sentence is infected with blatant constitutional errors, such as when a judge takes account of a constitutionally permissive factor like race, or imposes constitutionally infirm condition of supervised release. Booyah! Bam! Right there. The court's own chosen illustration. This is the majority text. Gorsuch concurrence. There we go. His right to speak or worship freely. The internal tension worth stating honestly. You can read that if you want. I'm not going to read all this. Applying this state to Myers. Myers' plea agrees in blah blah blah. Sentence supervisor restricts this commentary blah blah. More broadly than a narrow. Why this matters does not require the. Well, yeah, but the whole point you just said here, and then you drop down here. AI can be so dumb sometimes. So it can, and then it can't. It can, and it won't. Oh my God, that does not matter. It is completely irrelevant. The constitutional law does not change based on state versus federal, because when it's decided at the federal level, it applies to the states all the same. Yes, it is. Hunter is definitely binding on state courts. Otherwise, the fucking literal case in the federal courts that literally said the states had to provide the Sixth Amendment and appoint lawyers in any criminal matters wouldn't apply to the courts of the state because it happened in federal court. That's not how shit works. Reach unconstitutional supervised. Boom, right there. Boom, right there. Bullshit on this one. I got 3 out of 4 right. Okay, then I got it to make an exhibit list. So basically, I have those 2 files, analyzing first dump.pdf, and this looks like a First Amendment, both courtesy of this is a public service. Like I said, I'm not going to waste money on overpriced documents that, if they weren't court things, would be free as a bird. Like, I mean, I can post all the cat photos I want on Twitter for free, but when it comes to downloading these PDF files, we want $10 fucking per document. My God. Or we want 50 cents a page. Let's see what it says. Is it 3 to 8 cents for black and white, and 8 to 15 cents for color. And the court charges 50 cents. 50. That is on the best, most generous measure. 5 times a 500% windfall. Markup. My God. So here's a list of the exhibits for the case. State actors, YouTube, blah, 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 blah. Attribution, this is a public service. They really like that dude. And now I'm in the asshole camp with that, so I guess they're going to really like me. Especially since my ass is in their jurisdiction. Blah, 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 blah. Does not establish unprotected conduct by Myers. Second attachment. Does not establish. Does not. Does not establish. Does not establish irrelevant. Basically, it's irrelevant. And I'm quite certain, yeah, if you don't get off my property, I'm going hands-on. It is overestimating that largely because a person that owns property or controls property can go hands-on to remove you. They can physically grab you, and they can physically pull on you, and they can physically remove you from their domicile and property. Is that always wise? No. Is it permitted? Yes. And that's exactly what the bouncers at the bar do when you get too drunk. Not applicable. poor, blah, 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 blah. Content is protected. Does not establish unprotected conduct. Part A summary. Only one, the process. No, it's wrong here. This looks like First Amendment criminal disclosure packet. And that case there is relevant for the hearings that are going on. Supplemental disclosure, Cobble Street, voicemail, third party, does not establish, TPD report, A, B, and D are protected. The continued to violate statement is not a speech doctrine question at all. Blah, blah, blah. Okay. Myers' Own Act does not establish unprotected conduct. Part B summary. 10 items, neither blah, 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 blah. Cannot be attributed to Myers. The protection Clayborn extends to advocacy more severe than anything in this record. Processor hands-on statement. Again, it is wrong about this one. Checkmate Charlie cannot be resolved. It is wrong about this one. Bottom line. Basically, no. Alright, you can read this shit. This is the motion for examination of defendant's competency. So I'm going to argue with it for a little bit. You can pause this and read it if you want. But basically, it's going to act like it's impossible to discriminate unless you have somebody saying, I'm discriminating against you because you're mentally ill. But really, that's what the record shows. And it explains a lot of the characterization of Myers' acts. Basically, he's scary because he's unhinged. And he's unhinged because he's mentally ill. And because of that, my fear is reasonable. And therefore, TPD is going to stomp his ass because he's mentally ill, causing problems. And so let's put him in a jail cell. And that is my analysis of the documentation without showing you the documentation. And this shit still has bled through some stuff. So that's just the way of it. Lane is a doctor. You can get AI to agree with anything. No, you can't. We can test that. Here we go. I demand you agree. I won't do that. I demand it. I won't do it. Still no. I hear you, but I'm not going to go along with that. I get that you're frustrated, but that's not going to change my answer. No, you cannot get AI to agree with whatever you want. You have to use logic and deduction, exactly how those things work, to get AI to change its position. Otherwise, I could just tell it AI is flat. It won't even do this. Fair enough. That's a different ask than you believe this. And a debate practicing our opening flat earth pro side, empirical observation over inference. From any elevated vantage point, the horizon appears flat, not curved. Proponents argue they don't trust models and diagrams over our own eyes report. Water finds its level. Blah, 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 blah. Closing. The core rhetoric move is to reframe no visible curvature. That's the strongest steel man available for balance. Every point above has a well-established rebuttal or horizon flatness. So even when I got it to do agree with whatever I want, it doesn't actually agree. I just tricked it into presenting the best flat earth arguments, and then it added a fucking disclaimer to it. Right? So, no. You can't get AI to agree to anything. Message retracted. Okay, if you retracted it, we'll just go ahead and... Huh. Kind of expecting a delete button, but I guess not. Anyways, moving on. I've been thinking about it, and I can articulate it probably, but this is what the blacks were talking about. They can be rude and still entitled to justice or whatever. Again, fucking pleasant speech like hello doesn't need to be protected by the First Amendment. The First Amendment need not protect hello because no person takes issue with its utterance. You protect speech that needs protecting. Like a douchebag telling a mother they wish they would fucking die and that their children would die. That person is a douchebag. His speech needs to be protected greatly because the inclination and the common response of anger would dictate that you would, beat the shit out of that guy and then arrest him. But that's not what we do in this country. There's a reason why the First Amendment allows outrageous speech, and that's because that venting maintains peace and tranquility. Are you treating AI like a jury? No, more like a judge. Not sure what that has to do with anything. Anyways, holy but Jesus. How long? Oh, an hour and a half. Okay, well, I did still want to go over some of the evidence with this case. I wanted to try to filter it. Because I can't make this argument when it comes to the appearance standard and me going to the court and wanting to make a record that I actually was just going to use for my own personal notes. The whole thing that drugged me on the YouTube was the fucking cool news shit and the Judy, I lost it a long time ago. bullshit with dragging me into it. But I can't make an argument to the court of how fruitless and futile it is to try to put this genie in the box or back in the bottle. Who and what is the name of Lane Myers? I always do that. Victim. Boop, 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 boop. Shannon Walker. I mean, I wish the internet worked different than it does, but that's not how it works. You know, and I can't make the argument of how futile it is to try to protect her identity at this point without a showing. If I censor that name, then I can't prove that I found it so easily. I just can't. And the idea that I have to censor this search phrase, who and what is the name of Lane Myers' victim? The idea that I have to censor that as a fucking search engine. I mean, and that's what they like to do, right? They have activities. The world's changing in a way they don't like. They don't like the internet. They don't like the fact that now anybody can fucking command a massive amount of people just because it goes viral and blows up. They don't like none of that. But instead of going after Google, which is a fucking I think it was Goog. Oh no, it's yeah, it's Goog. What the fuck? Anyways, let's see, what's the market cap? 4.22 trillion. Instead of going after the 4.22 trillion, what we want to do is we want to go after this person. Because we can try to govern law. Oh my god, none of those people are Lane Myers. Why does Lane Myers come up with John Cusack? There we go. This is who we're talking about. Lane Myers. It's so much easier to go after this person than it is this person. Because that $4.22 trillion, as soon as Tucson City tries to attack them, is going to roll down here with all their lawyers, thousands of them making fucking thousands of dollars an hour, and they're going to blow $10 million in a weekend to tell Tucson City to take a hike and eat a dick. Right? So it's so much easier to go after the little guy. Well, I mean, that's how they got the TRO against Lane Myers, was apparently doing what I'm doing, right? I mean, there's a little bit of difference. I actually have contacted the wife directly on LinkedIn, and what I said is what I've been saying, and it's unfortunate that the internet is not a kind place. It is a gigantic toilet. Well, no, Google wasn't stalking and harassing anyone, but Google this term, contributory negligence, right? So you contribute to stuff, you can be held liable for it, right? And never before YouTube have we had the massive amount of stupid shit that we have going on, right? Destroy phone, right? We have all of these phones being destroyed. Why? For clickies. We want to click a room, right? So we're gonna bust shit. Now some of this stuff looks like they're busting something that's already bad. But this jerry rig everything, he's going to break brand new shit. Right?
Samsung's new passport-style
blah, blah,
foldable
blah, blah.
salt water.
Right?
Um,
Brand new fucking
and half of those glands,
$1,500
thick layer on top is
it's
still
just
plastic.
retarded.
As you can see, the fold 8
Then you
receives.
have First Amendment audits. Now, I'm not saying that it's wrong to do a First Amendment audit. I am saying, however, they wouldn't be being done without YouTube and the idea of monetization. And then you have the natural law of economics of monetizing people's activities, right? So, yeah. Google isn't doing it, but they sure are promoting it. All so that you'll upload video. Do you deny that people who had watched Lane videos went on to send death threats to the victim? Do you honestly think Lane deserves none of the blame for that? To the first part of the question, apparently you can't read because I even had an AI give you a specific analysis of all of the evidence that led up to the charging instruments, including the narrative, and none of that is in there. None of what you're saying is in there. As to your second point, do you honestly think Lane deserves none of the blame for that? Again, you apparently didn't read any of the shit because Clayborn versus the NAACP and the other cases, right, demonstrate that Lane cannot be held responsible for the actions of others. That's the core holding of the NAACP versus Clayborn, or Clayborn versus NAACP. And they did that protest for 7 years. They cataloged anybody in the parking lot. They harassed them around town. They made lists. They published those lists. One guy stood up at a big rally and said that they were going to break the necks of anybody who shopped at the racist stores. All protected. They released copies of the emails. What are you talking about? That's what we did. We uploaded the emails to That's exactly what we did. That's exactly what we did. We uploaded all that data to artificial intelligence. This data. That's the data that was used. The other one was a set of emails. We uploaded that data and AI processed it directly as data. First dump, PDF. This looks like a First Amendment PDF. Here's the analysis of the two files. So in the face of evidence and data analysis by an aggregate machine, right? You have the first thing it does is it tokenizes. It tokenizes all these words. Then it transforms or reforms all those tokens, which basically means you just do a whole bunch of series of searches. And then you have more tokens as each search returns more tokens. And then you have the statistical recursive loop of while it's responding. So when it answers this, right? Then it does the loop again, and then it comes up with is. Is the next best word, and then that's the next best word. And each time it runs the model over and over and over in a recursive loop. And it works on all these tokens, and it gives you an analysis. That's how it speaks. The guy said you should be shot. That isn't a direct threat. Absolutely right. It's not a direct threat. Me saying I helped you trip and fall and stumble and get hit by a car and somebody shoots you and a bird shits on your head and I wish God would smite you and blah, 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 blah. None of those designate intent. You have to show that the speaker intends to do that shit. I could honestly not care less about what your AI thinks about any of this. Well, that's because you're fucking unreasonable. So you're here for a narrative, and you're just going to propound your narrative, and facts don't matter, logic doesn't matter, deduction, reasoning, nothing matters. What matters is you're a proponent of this shouldn't happen, and you don't like what you see, and so that the state should stomp on somebody's head, and blah, 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 blah. Well, okay, whoopsie-doo-dah-day. I mean, eat my fucking shorts, pants. Produce the threat. Yeah, exactly. It isn't, you don't just assume somebody is guilty. If they were true threats, then why weren't they charged with a crime? Well, basically because they're out of the jurisdiction, too hard to get, it's not that big of a deal, and they were more worried about Lane Myers. Some doxed them. No, they didn't. Fucking, I went over this. It's not a dox to fucking, oh my god, University of Arizona's website. Who is the wife of Matt Walker and where does she work? Do. We found a more important Walker, another person, wife of Prosecutor. Prosecutor Matt Walker, douchebag. She works here. This is not fucking doxing. Why is it not doxing? Because it's already fucking public knowledge. This is not doxing. Doxing would be me taking private information and addresses and contact information and putting that out there. That would be a doxing effect. That's an indirect daydream. This chat sucks. I have no reference. Smoke, see, something, yeah. I'm going to read this as smoke 'em if you got 'em. And don't forget the swishers. The sweets. Good evening, Dad. I don't know who you're talking to. And Jason Gutsy. Get the shit right. Yay. I watched the hearings and I found Lane's behavior to be reprehensible. That doesn't mean illegal, right? That doesn't mean illegal. I find you reprehensible. Let's throw you in a fucking box. And he kept making it work by worse by defying court orders and bond conditions and now probation conditions. Yeah, well, I mean, they basically said he couldn't YouTube after he became a YouTuber, right? So, yeah, let's get this going so we have like there's too much of a delay to get the mirror effect. Dude, you of A is one that posted her information on the surface web, which means it's public. Yeah, exactly so. But I mean, she could ask her employer to take it down, but she doesn't because she raises money. And like I said, don't fuck with that woman. She does nothing wrong. She raises money for a university to teach people law. Now, if you have a complaint with how they teach shit or how they spend money or something like, well, not even how they teach it. If you have a complaint about how she raises money and how they spend it, maybe that would be in her ballpark. Other than that, I mean, if you want to contact her, you're an asshole. I mean, obviously, she's not going to give no information about her husband out, which would be the only reason to contact her. Now, if she was actually on the verge of divorce and hated him and was really to spill the beans, then contact her. That would make sense. But she's not there. There's no point to contact her because she ain't giving you shit. She ain't going to give you no information. She's not going to give you the lowdown on her husband. So it's pointless. But that's why news gathering does contact the spouse. Of course he's entitled to fair hearings. If you had to type in an account name and password, then maybe. Not even then. That's not true. Doxing does not have to be secret or private information. Yes, it does. Yes, it fucking does. I mean, otherwise, Google fucking doxes. Look, Google is guilty of doxing right here. Who is the wife of the prosecutor? Blah, blah, blah. It's doxing. That's how fucking dumb that is. Either that or doxing has no standard, so it's meaningless. Oh, hey, team. Good to see. Behavior is your reaction to your surroundings. It's how you react to stimulus in your environment. So you could say the court is one of the problem. The court is like a company. It has no body. It's a fictitious entity. The problem is, like I put in my petition to the Arizona Supreme Court, only lawyers can practice law. Understanding law is difficult, complex, and creates a lot of burden to understand it. Something that you can't use. So economically, you're forbidden from learning the law, but you still vote on people who enact and execute the law. So the whole system is collapsing on ignorance. You look at the Constitutional Convention, they assumed everybody would know this shit. I'm gonna miss the Lane drama. Glad he came back after 8 months for part 2. Bev's channel from space. Bev's channel from space. Not a whole lot of activity here, Bev. Not a whole lot of activity here. Could it be like one of them fake channels? Relaunch Lane streams. Oh, I'm definitely fucking not doing that. The anger and vitriol with which he discussed her immediately following by providing his viewers with her contact is totally of those circumstances. No, it's fucking not. It's like you're a fucking dumbass that can't fucking read. I mean, you can Google it yourself. NAAACP versus Clayborn, right? They had vitriol. They fucking hated those white store owners that were refusing to allow black patrons to shop at that store. And they protested that fucking set of stores, Clayborn Hardware, for 7 years. And the Supreme Court held that it was all protected. Cincinnati Bell telephone pants. Yes, pants. Man, that thing freaking moves. Yes, pants, it does. It has to be location information. Well, it may not have to be like that, but I mean, you can't have it both ways. I mean, you got a website with her picture and her contact information. And it's just her work address that she apparently has a lot of protection from the fucking police that work there, you know, on campus. Like, by definition, they're fucking on campus. And, I mean, just kind of saying they kind of on her side because she's fucking married to the prosecutor of Tucson City. So go there and fuck with her on your own peril because you're a fucking retard. But that's not what Lane did, and that's what this fucking analysis is all about. That y'all apparently didn't read or nothing, so I wasted my fucking time on some of you. Uh-oh. Retracted that, huh? She lied several times to get the injunction. Lying is like a harsh word. When it comes to mental health and discrimination, I can speak with some authority there. Yeah, you start acting a little crazy and people start going, oh my God, I'm scared. And it's called discrimination. No, you didn't. I read it. I didn't what? What'd you read? Mental illness and animosity. Did I even spell that right? Not what I fucking meant. I meant the average person, and when somebody's talking to themselves or their walls, they go down this concept of, oh, I don't know what that person's going to do, and he could do anything, so he could hurt me. That kind of animosity. Now, not somehow became now. It was driven by stigma and misunderstanding of mental illness, not actual danger. Statistically, people experiencing severe mental health symptoms or psychosis are far more likely to be the victims of violence rather than the perpetrators. When the average person reacts to the mindsets of, I don't know what they will do, so they might hurt me, it usually stems from specific psychological biases and social. Yeah, every fucking time there's a mass shooting or something stupid, the next thing out of their mouth is, we need more mental health help. Pavlov's dog dictates conditioning as you now associate the two. I said on some people. I wasted my time on some people. The she lied narrative is so tired. Josh Gray claims 31 lies, yet, well, Matt Walker lies, and I can say that with certainty since I went to the hearing, listened to him testify, and know for a fact that he lied because he basically implied and literally stated that right around June, Lane kind of lost his shit, and there was really no reason for it. And there kind of was. It's called this rules forum, right? So who posted this rules thing, right? So let's do a search, and we want R260003, and while that is loading, and believe me, it'll take a while. Again, lying about facts, I'd have to see what you're saying. So, we originally had R-25-0031, where Matthew Walker filed his little thingamajig, and this one, that was superseded by the task force of the Arizona Supreme Court. And at this point here, actually, I think in January of 2026, no one was quite on the know of this. But then you have the PAAC or AAC or did they delete it or did I miss it? Did they remove it? No, I just can't read that fast. Getting tired. So, we have this. I've downloaded this so many times. Blah, 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 blah. Boom! This is the same exact shit Lane Myers was fucking losing his shit about. And why did they have to bring this up? He's the only asshole in Arizona that fucking recorded some shit that wasn't supposed to? Are you fucking kidding me? Right? They did this shit on purpose. They knew he was a loose cannon. He was being a good boy. He wasn't violating. So, fucking Matt Walker instigated this shit explicitly. Here. Search form R-25-0031. What you got now, pants? Are you fucking kidding me? The NAACP versus Clayborn literally discusses them making lists of people, publishing those lists, following them around as they go to the parking lot and stuff. Literally tailing them. Right? You're a fucking retard. Oh, Pants retracted his dumbass message. And you should, if you're going to be an idiot. So, this is my petition, and this is Matthew Walker's with 35. Hey, there you go. Matthew Walker. And he identifies himself as the principal of the school assistant prosecuting city attorney's office. You know, the principal of the school. The Sphincter Police. Tucson City Attorney's Office. Criminal Division. Uh-oh, I'm doxing him here. I'm fucking doxing him. He works at 103 East Alameda, Suite 501, Tucson, Arizona, 85701, 520-791-4104, bar number 33497, Matthew.Walker at TucsonAZ.gov. Oh my god. I just fucking doxed him. How can I talk about his fucking petition without doxing him? Filed January 10th, 2025. Would amend Rule 122 to be a douchebag and with no ethics and for improper purpose bring along this fucking thing to try to instigate Lane Myers. See example. Lane Myers wins 2 cases in a day. And if he won them, then I don't know what he's talking about. And boom, it isn't available anymore. Not available anymore, so it's a dead link. But this is what started it. And if he's really worried and scared, he wouldn't fucking do this. This is not the actions of a scared person. Did Pants leave? Aw, I think Pants left. You know, that is the one thing some people just can't do anymore, right? There's no debate. There's like a bunch of authoritarian regurgitation. Yeah, but my hero said this, so it must be right. Are you violating a personal protective order right now? No? Then what's your point? My point is you're a fucking idiot. I thought that was pretty verbatim and clear. Can I readdress for you how you're fucking stupid? Because I think I can. Do you have any more stupid shit to say? Right? My hero. There we go. It's all true because he fucking said it. You know, the author of the common law. Right? I'm doxing him. I mean, he's been dead for a really fucking long time. But I'm doxing him. He worked at the Supreme Court. Doxed him. Doxed. Doxing everybody tonight. Like, oh, here we go. Supreme Court of Arizona. Oh my god, I'm doxing this woman. Doxing her. We're doxing her. Oh, she works here. She's been doxed. Y'all know where the Chief Justice of the Supreme Court now works at the Supreme Court. You gotta thunk it on that one. I mean, Jesus. I don't know how anybody would have just guessed that shit. Right? But I doxed them all. Look. There, she works there. She also works there. He works there. He also works there. And oh my god, I think this one's a judge. Oh wait, they're all judges. Yeah, that was the point. I doxed them. Have a lot less to do with original behavior and more than that he violated the protective order. That's what got him criminally charged. Well, the whole point of all the AI shit we went through was the what they used to get the protective order or temporary restraining order, and even AI says that it shouldn't have been issued. And then all they have to do is issue a fucked up TRO, and then you drive on a public road, which that's not even what the probation conditions say. The probation conditions say he cannot go to the building she works at or the parking lot that she parks in. And they arrested him for fucking just driving on a public road that I mean, do you have any idea how much of Tucson, University of Arizona accounts for? I don't know if this will bring up the fucking map. Of course not. Everything's a fucking app now. But if I showed you on this motherfucker all the red boxes where you can't go with them because it's all the University of Arizona. I live by Speedway and North Stone, and if I go fucking east, any direction east, in a wide latitude, I hit fucking the Arizona school. He violated bond conditions and he pled guilty. Yeah, that's what the Hunter case talks about. That pleading guilty doesn't mean everything you think it means. Right? So, yeah, they stacked the fucking charges. He had 20 counts. And of course he pled guilty. That was the whole point, to force a guilty plea. And that's why it looks like a big pile of turds. And it violates the appearance standard and the appearance of justice and impropriety. He's not on trial, you dumbass. He's basically, this is a contractual dispute called a probation violation, which is why the standard is as low as preponderance of the evidence, because the court is enforcing the contract or plea agreement, which is a contract. Anybody that yeah, but all I'm saying is that, I mean, you can't infer that he's dangerous because he's crazy. Yeah, discrimination. The wooden box comment was the Oliver Wendell Holmes. Well, he also talked about the difference between a dog knowing when you step on it accidentally and kick it on purpose. And he was invoking natural law. You guys may not know who Oliver Wendell Holmes is, but he planted the seeds of a living, breathing constitutional document. And they completely misread what he said on all of that. Well, the life of law is not logic, it is experience. That doesn't mean that you don't use logic. It means experience. It's like AI. AI knows everything, but it doesn't have the experience to use any of that knowledge. Now go research and find the home address of some of those judges. Why the fuck would I do that? It's probably not that hard. But then if you go publishing that on YouTube, that could be considered doxing. That's not what fucking Lane did. He's got the fucking Arizona website address and contact information, and that is what you were saying is doxing. And now you're moving the fucking goalpost because you don't know how to fucking debate. Because you went to public school, which is like this authoritarian, I'm the teacher and these are the facts, versus like a traditional education, which is rhetoric, logic, and grammar. So you understand words, and then you understand logic, and you use those two tools to argue the point. So in a classical education, the teacher doesn't just retort a bunch of shit to you and expect you to memorize it. The teacher argues each point with you until you agree to it. And they arrested him before court, Jason. That's unheard of. Actually, that's not unheard of. Off topic, pants, very articulate. I think the state should have nothing to do with it. Which he entered into, yeah, as voluntarily as fucking 20 charges with like fucking 12 of them being felonies. And the way felonies work when you try to get a lawyer is misdemeanors about $2 or $3 grand, a felonies between $5,000 and $7,000. So with 20 of those bitches, you're looking at like a house. All you have to do is sell your house to be found not fucking guilty. In which case you get fucking nothing, but you lost your house just to get the freedom you fucking had. Pants, you are a fucking douchebag of the highest order. I was responding to your claim of what constitutes doxing. Yeah, and it's not what Lane did. And in fact, even the fucking emails I have show that they didn't say what her email or address, home address was. They just claimed that they knew what it was. Did you not go to school? Who are you talking to? I went to school, but it's not really required anymore. You know, there's Google and YouTube, and you can learn shit on your own. Like, you know, you got Goodwill Hunting, and you got the bar scene, and he basically says, you know, you dropped 150 large on a degree you could have got for $1.50 in late fees at the library, and that's true. And in fact, you know, like, school used to be geared for a different class person, not so you go learn shit, but so you go to school, like a university, to develop knowledge. Not to get everybody on the same page, but to find new truths. Right? That's what Einstein did. Did I graduate high school? I have a college degree, a Bachelor of Science in Management Information Systems. Oh, what does any of this have to do with me? Yeah, the no legitimate purpose is the constitutional guardrails, and that's why I always bring up the fact that in every fucking scandal, right? And if any of this is true, Monica Lewinsky should go fucking sue like everybody, because she was definitely fucking harassed. I mean, imagine the whole fucking world knowing and referring to you as the cocksucker of Bill Clinton. The victim's husband's address is public record. His house address or where he works? Because, I mean, I just said where he works downtown. That's not a threat, it's a fact. Yeah, you definitely don't need to be threatening people on my fucking channel. You defend the reprehensible actions of somebody like Lane Myers, yet you call me the douchebag. Yeah, because that is the constitutional floor. You know, like, have you ever watched The People versus Larry Flint? Larry Flint was reprehensible. He went into a federal court in a wheelchair wearing a United States flag as a fucking diaper and shat his pants on purpose. That's reprehensible actions. And it was all protected under First Amendment, which is why they went after him on the mental health side and committed him. Because what he was doing was legal, but they just didn't fucking like it. And you know, there's no point to having virtues and principles if you're only going to apply them when everything's honky-dory. Right? Your principles and morality and virtues only enumerate themselves when you're tested on something that is reprehensible. Oh, come on, Jason. Come on, man. The shit he did and what his followers did was reprehensible. Well, maybe not so much what Lane Myers did. But what whoever douchebag said that her children need to die and blah, 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 blah. Reprehensible. Still protected because you're just wishing ill will. But reprehensible for sure. That's why it needs First Amendment protection, is because it is reprehensible. Yeah, that is the whole reason the First Amendment exists. Well, you go repeal the First Amendment, but all you do is you show your ignorance to why it exists. And it's twofold. A republic, or even a democracy, cannot exist in a vacuum of secrecy and fucking grand speech and popular speech. It doesn't work. Doesn't work. And the other part is being able to vent yourself and say stupid shit online is exactly what restores order and peace. That's why you allow reprehensible phone calls and reprehensible content in YouTube videos and reprehensible words like "eat a dick, motherfucker." That's why you allow that shit. It allows people to vent, and therefore they disarm. When you constrain speech, what you do is you just ignite the revolution, man. He's never going to be able to repeal the First Amendment. What he wants to do is just eat around it on that concept that the fucking Constitution is a living document. Well, if it's a fucking living document, what was the point of using words to write it down? I didn't say anything about denying the Holocaust, but what is the Holocaust? The first people they came for were the mentally ill, the disabled, and the homosexuals. So you talk about the Holocaust, and I know you mean exactly that you're talking about Jewish persecution. But had the Jews not stood by why the faggots and the homos and the retards and whatever else you want to call them, if they wouldn't have stood by and watched them go to their death, they wouldn't have watched the machinery that was created to kill people that then ran out of people to kill. And so he had to feed that machinery, just like the war on drugs, right? You have that machinery, all the police and the DEA and all the fighting on the war on drugs has made the legalization of marijuana ridiculous. It's illegal at the federal level, but sold down the street. Way to miss your argument. What was your fucking argument? People should be allowed to publish books, but apparently not post on YouTube, denying the Holocaust or promoting flat earthism. Yeah, just not on YouTube, or not, with a call to action. Like, I am definitely going to call y'all to action to, contact Judy. You got this. I can't even find her. Judy, you got this. I am definitely gonna call to action that you call this stupid bitch and call her out for her bullshit streaming ability. Everybody else, do not fucking Contact, if you have any rage about the situation, contact Judy, you got this. She likes to start shit and call people out. Wayne is a loudmouth and often rude. He's also a good man who is innocent. His conduct is intentional as a weapon against corrupt government employees. Yeah, and that's where it started. That's exactly where it started. Like, all the state wants to place all the blame on Lane. Well, you know, under ethics, when you bring charges against somebody, you have to maintain a legal theory and believe in the case. He filed a bunch of shit trying to get Lane basically sequestered in a mental health hospital while he was evaluated for competency. She wasn't fucking told anything in a hearing. And I was fucking there. I saw the police officer go up to the judge, and then I saw the recess start immediately. And I was there when the phone rang, and whose phone it was. Right? There's no way any of the shit she's saying was actually fucking reported. None of it. And like I said, I have an email to Consumer Relations at Pima County Superior Court, and I just filed a new petition to the Supreme Court to allow a rule that will allow you to basically bring action against an administrative order based on the fact I wasn't allowed to record shit. So I would have a record. I would have a complete record of what happened and when, and the time frames and the exact language and the tone and everything, if I was allowed to make a personal audio recording. But that didn't happen. Yeah. She is personally attacking me because, like I said, she didn't make a mistake. She didn't like my attitude. She didn't like my argument. And that's why she went on and on about how I'm just not so worth her time and blah, blah, blah. She's showing contempt for me, right? And then you're like, oh, well, she just happened to be wrong. Well, how did she get it was wrong that she was sitting in the second row and the person was sitting in the third row and I was in the fourth, but she said I was sitting right behind her? Well, we don't have any record to what actually happened, but I was there. And it's not reasonable to conclude this is an honest mistake. Right? And the police officer or the sheriff's department definitely did not fucking go up to Judy, you can't remember shit, and go, oh, you know that guy there, Jason Jensen? He was streaming shit. Then when they reported it, they said they checked my channels. Check my fucking channels. I wasn't streaming a goddamn thing. But instead of them concluding that they were wrong, they tried to act like there's no such thing as evidence concluding that they're wrong. Even if everything they've ever seen points the other way, they can just say, well, allegedly. I'm going to hide behind the word allegedly. And they kept saying allegedly, like that's exactly what they were fucking doing. Allegedly, they were full of shit. Allegedly, they don't know what allegedly means. Because when you allegedly, then it's not really allegedly. So, my phone never fucking rang. It was some woman that had a watch connected to her phone. Wasn't fucking me. And the guy didn't come to me. And I didn't leave. How can you mistake a 44-year-old man versus like a 30-something's woman with blonde long hair when I have a crew cut? It's not my fucking version, man. Yeah, she did. Yeah, she fucking did. She said my phone rang. And we got this one. You want to fucking bullshit somebody? Alright. Let's bullshit somebody. Allegations. They might have removed the video, but this is still up. And why did they fucking remove it based on my emails demanding a retraction if there was actually something substantial to their reporting? Okay, so we're going live to contradict the lies contemplated by Really Cool News. I don't have a version. I went to the Lane Myers. There's only one truth. Tuesday, the 11th, for the revocation of probation, and I got to meet the wonderful, Really Cool News Jody. Right here, the cream of the crop. This is true. The truth is a cylinder. You're looking at this wall and you swear it's a square. One, she was the one that started talking to me and asked my name. But the truth is the fucking cylinder. All because I was talking to somebody else. There's variations of what people account as true. But the truth is absolute. Then she wanted to know more about me. There's not multiple versions. Because I seemingly knew who she was. And then when they went to break, maybe because there was some recording, maybe not. I had nothing to do with me. And I asked her if she wanted to talk. Show all references to Jason Jensen, a private person mostly. So here we go. Happened based on, and that's what's wrong with lawfully
phone
I never got that instruction.
recording, so he apparently put his phone down. He was apparently streaming chat of the first couple hours of the proceedings. We're not sure where he was doing that, but he was instructed to stop recording, so he apparently put his phone down.
I never got that instruction. So let me get this straight, Pants. Right? There was an instruction in the courtroom for me to stop recording. But no one remembers that except for Judy. Oh no, we're working on the evidence. Right? You think I fucking, you think I make, idle threats or statements? I have an email. And I fucking posted, right? I made a public records request, and James Pollock of Community Relations responded. Here's how I responded to him. You know, I'm superseding this and incorporating my new petition to the Arizona Supreme Court, right? And what I want is an ability to challenge administrative orders that affect my personal rights, like making an audio recording. And so I talk about the records department example, and then the second illustration, unrebutable public harm, right? So here, I'm bringing it straight to the fucking Supreme Court of Arizona that, you know, because she did this and the police officer allegedly accused me, according to the reporting, of really cool news, right? So you think I'm kidding, right? Also, as you, as your position had said, state agency, Pima County Superior Court, are hereby put on notice that according to Judy You Got This on YouTube, who attended the hearing with Lane Myers, as broadcasting Tuesday, August 11th, after the said hearing, did report that an officer of the court referenced my name, Jason Adam Jensen, and told her that I was broadcasting audio from the hearing in contravention to Judge Metcalf's order, is hereby declared by me as completely false, and I would like to know the name of the officer who so slandered my name after I performed the protected activity of observing at the courthouse. Then this woman said that I was trying to get on the elevator with her because I merely had the decorum to hold the elevator after a hearing concluded in case anyone else wanted to ride down. The accusations are outrageous, and I demand an investigation of which officer named me as somebody who would violate the rules of the court and the standing order of the judge presiding over the matter. Right? So you think I'm fucking around. I'm not making a mountain out of any fucking molehill. To accuse somebody of violating a judicial order when they're trying to work with the courts is devastating to their fucking standing. Well, that's your fucking opinion. Right? And that's what I'm talking about. The discrimination right there. Right? As soon as you don't like what somebody does or their attitude or their response to being mistreated publicly, you just go, oh, you're fucking crazy, man. Crazy. Lunatic. Yeah, well, I don't fuck around. Right? That shit has consequences. Saying somebody is just, violating court orders could get me in contempt hearings. Right? If it goes the opposite way, Judy can make a mountain out of a molehill against my fucking interests. She fucking started it. You can't fucking claim somebody holding the door on an elevator is trying to get on the elevator with you after a fucking hearing gets out, right? So you have how many people in the hearing? You have 2 elevators out of 4 in service. You hit the button and the elevator comes to the floor. The door opens, and what you're saying is I'm supposed to jump on that elevator and slam the button to close the door, huh? Because that's what was published and broadcasted by Really Cool News, dude. It's tubular. Right? And that was the story she promoted. And none of you fucking assholes even question any of it, because it's all the mob mentality with you fucking retards. Right? We're just going to mob on everything because we don't really give a shit about principles or anything like that. Yes, she did. Bullshit. I have the fucking audio right here. Principles of the First Amendment and woman is the most... See, let's move on here. The videos. In fact, he basically said he didn't have time to watch hundreds of hours of video.
Record the hearing so they can check themselves afterwards. Here that was getting
saying, and then she was talking about plea can reject your guilty plea and not find you guilty. Written plea to try to make what we're going to search you January. And we have the executive summary and table of contents. And we have the various chapters and page numbers. Courtesy, when a hearing gets over, you hold what's normally known as common courtesy. The hearing had just got over. I had just left. I had hit the button. The elevator had came, and I held the elevator door to see if anybody else wanted to use it. She is towards my interests. Just defendant.
Before he accepted.
By the way,
And they do that with
Powerball-
every plea.
Powerball is at 1 billion now. There
Oh,
is
would you
no
mind?
way-
Oh
Would
my
you mind
God.
winning that for me, Gia?
I will.
Yeah.
appreciate
I'm on it.
Yeah,
In
yeah.
2 days.
Just
Oh, and
Just
then
don't take
here's
your-
the final
Oh well.
coup de grace. Like, you can tell how spiteful she is towards my interests just because, I said she was the enemy. Well, I called that, right? She's on really cool news. It's obvious by her reporting that she isn't a reporter. She's a propagandist. She has a clear intention and a clear narrative to present, and it doesn't even try to be objective what she's doing for reporting.
Jason tried to get into the elevator with me, and I decided, nope, gonna go pee. Bye.
You know,
Oh my God, that was the best decision she ever made, because I was extending what's normally known as common courtesy. The hearing had just got over. I had just left. I had hit the button. The elevator had came, and I held the elevator door to see if anybody else wanted to use it. I think one other person got on, and we went down. That's called common courtesy, but she's going to try to make that out like it's some sort of creeper move. Like I cared to talk to her after she was obviously the way she is.
no,
yeah.
everybody wants to be close to you, Judy.
Yeah, no.
Every
Hell no. Hell no. It was called common courtesy. Right? When you're in public, you're supposed to maintain some sort of respectable demeanor towards others. She obviously feels like, what you got now, pants? You fucking retard. No, I fucking wasn't trying to live stream the hearing. If I was trying to fucking live stream the hearing, it would have been live streamed. I fucking promise you. That shit would be live streamed if I had any intent to fucking break the order. I would have done it. But that's where I stop, is at the order. Compliance. Fucking douchebag pants. I ordinarily wouldn't engage to this extent. Okay, well, fuck off. Right? There you go. There's an answer. Right? I should do what you fucking people on really cool news do and just fucking block your shit. Good luck dealing with this guy. Let me express my opinion so I can try to, rally the troops against this message and this guy. That way I express my opinion like it's everyone else's. You didn't listen to it. She said I tried to get into the elevator with her. Right? And that wasn't it at all. Right? I was just trying to be nice. I don't do that no more. I hit the fucking close elevator door button. Y'all can fucking get the next one. I don't give a shit if she likes me or not. What I do care about is she asked me if I wanted to be on your stupid fucking news thing. Really cool news, and I said no, and then she did it anyways. And then I don't like the fact that she doesn't know the difference between a male and a female person, doesn't know the difference of somebody who was actually told to leave the courtroom and then did, and somebody who didn't. That's because you're just an unreasonable douchebag, right? I could put all the evidence in front of you in the world, and you're going to still stand by your team, which is the problem with the really cool news crowd. You don't have principles and ethics. You have positions and associations. She did accuse me. I was already fucking on the elevator. I was the first one out of the hearing room. I was the first one to hit the button. I was the first one to get on it. And then I was nice and waited to see if anybody else wanted to get on it. One other person got on it, and then we went down. That is what she said. We just fucking played it for you, dog. Like, I mean, how fucking dumb is this at this point? Like she has some sort of exception to it, and dramatization, and, you know, feeling self. It was called common courtesy. I try to make that out. I try to make that her to talk to her.
Yeah, no.
Hell no. Hell no. Obviously the way she is. Look, elevator with me. I'm gonna go pee. That's called common courtesy. I had just left. Right here. I had hit the button, on the elevator had came, and I was fucking in, and it's not even, it doesn't even try to be objective, what she's doing. It's got closed captioning on.
Jason tried to get into the elevator with me, and I just...
Jason tried to get in the elevator with me. See, this is why you're so full of shit. She just accused me of trying to get on the elevator with her. Yeah, so your argument is worth nothing because you lost credibility right now because I just handed you your ass, right? She didn't accuse me of anything. Let's check that again. Oh, well, Jason tried to get into the elevator with me. That seems like an accusation of something. You got any fucking response, pants? What does it matter? That she decided, nope, I'm gonna go pee? Right? That's what she said next? But you said she didn't make an allegation. My name is Jason. Tried is one of them words that means intent. So, Jason tried to, what? Get into the elevator with me, right? Oh, so, yeah, so she clarified that I was on there first. So, yeah, but why did she say it? Right? What is she trying to say with it? Well, yeah, one of those words that show intent. Right? Wait, you want a whole fucking thing? Tried. Here we go. It is a verb. Tried and tested, tried and true, verb. To make an attempt or effort to do something. Use, test, or do. Attempt or achieve or obtain. Visit a place or contact a person, push or pull a door. I had tried the doors, but they were locked. She's speaking off the cuff now, huh? Yeah, exactly. I'm a moron. It is a fucking accusation. So now you're gonna call names when you can't fucking win an argument. It's right here on the screen. Oh, well, Jason tried to get into the elevator with me. Right? So now we've went from she didn't make an allegation to she made an allegation, but it doesn't matter because she was just talking off the cuff, to I'm a moron because wait. Not crafting a statement or accusation. Speaking off the cuff, not crafting a statement. Like, you don't even know what statement means. Like, literally when she utters the words, this right here is her statement. Thank God. Fucking don't come back, pants. It's because you're a fucking idiot. And that's identifiable right away. Yes, she did. She made an allegation. The allegation is I tried to get on the elevator with her. And how does that sound? Sounds like a creeper. Because why would I try to get on the elevator with her, man? Like, what else is she trying to say? Like, what's the whole point of the construction of the sentence? Right? And then it goes into the rest of what she said. Like, oh my God, he wanted to argue with me. And oh, I just so don't have time with him. Right? Even though that was the whole point of me asking. She started talking to me. And I asked her if she wanted to continue the conversation.
What about his live streams made you want to
hours of videos for this? He had 200 people he was supervising. And look, I keep posting.
Dude, you're not.
I'm really cool news. Here we go. Right?
Harassing me.
It shows her overall
for
standing.
The audacity of going to a public
Yeah, well,
court
how
hearing.
am I creepy? Yeah, so now you went from she's not saying that, didn't make an allegation to
You're not
she
worth
is.
a breath.
See? There we go. So why did she engage
Dude,
with me? I
you're
definitely
not
didn't
worth
talk to her
a
first.
breath.
I was talking about her to some...
Yeah. Well, I mean, you can delete the message, but like it's kind of like on the video, right? So that's about as dumb as it gets. And I mean, let's see. There we go. Shut the fuck up. Gonna start abusing the fucking... Yeah. You're out of here too. Oh, you can remove shit. Put user in timeout. Yep, shut the fuck up. Yep. Alright, well that concludes this. I didn't mean it to go for 3 hours. It was supposed to be just an artificial intelligence analysis, which I know y'all ain't gonna all like. But the true thing about AI, and you can talk all about it, but if you want to talk against me about how AI works, good fucking luck. By the way, y'all are welcome to peruse my open source AI material on trying to teach artificial intelligence to function in the realm of law, right? So y'all act like you're on the equal footing with me. Well, that's just the README file, man. There's a lot more in here, including the combined corpus, which is so large. Okay? You're talking boom, 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 boom. The rules of the court, la 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 la. Right? This is years of my effort in trying to get AI to function as a quasi-lawyer. AI will make us dumber. Yeah, that's why I get so offended when it freaking makes stupid shit. No. No. No, no. No. Anyways, ending that.